We conclude that it is likely that Trump lawfully exercised his statutory authority, which authorizes federalization of the National Guard when the president is unable with regular forces to execute the laws of the United States. In conclusion, Gavin loses again. For the reasons above, we grant Trump's motion for a stay pending appeal. Gavin Newsom having a tough time out there being a governor and a man. He now loses again in the Ninth Circuit. And this was the one case about the National Guard where he came out and said, I'll be in charge tomorrow by noon. And then, of course, he was stayed immediately by the Court of Appeals. But then we saw that this went to oral arguments, and then we had a little bit of an interesting debate back and forth with the very young man from California and the other dude from the DOJ. And the judges in the Ninth Circuit didn't seem like they were buying the oral arguments at all, and the arguments that Gavin was arguing, saying that they had to essentially go through his office predominantly, that this was not a rebellion, and that Trump was not in compliance with the statutes, saying that that means Gavin is back in control. Well, now it is official. Judge Breyer, the judge who issued the terrible order in the first case, who got stayed immediately. Remember, he's like, Gavin, you're in control. Gavin's like, yeah, tomorrow. No, you got stayed because that judge, Breyer, who is the brother of a Supreme Court justice who's no longer with us, is now the person who is getting stayed, and stayed indefinitely now, pending the course of this appeal, because his decision was so terrible. But he's going to come back and try to keep this case. We have our friend Margot Cleveland, who is reporting on this over on X. She listened to the hearing today because the Court of Appeals kicked this back down to him, and then he's going to say, well, what do I do with it? This came down from the judges. We got to see them in oral arguments previously earlier this week. Mark J. Bennett, Eric Miller, Jennifer Sung, the circuit judges who were seated there mostly mute. They write, all right, here's the opinion of the court per curiam, saying, you know, in the U.S. Code, Congress passed a law that said the President of the United States is authorized to call in the National Guard. And that's what happened. In fact, the president did that and ordered 4,000 people into service for 60 days. So then Gavin and the rest of the libs said, whoa, what are you doing? You're trying to enforce federal immigration law against illegal alien invaders on our streets who are waving Mexican flags around, endorsed by the president of the Senate of Mexico, who thinks that the geographic southwest of the United States belongs to them. Also endorsed by Claudia Sheinbaum, the president of Mexico, who says that if we dare tax their remittances, that they're going to mobilize against us and do what? Yeah, all of them. So our own politicians, who may have 3 million illegal aliens in LA alone, who knows, who are their constituents, who probably are responsible for 5 seats in California, maybe more than that, in Congress, and billions of dollars in federal government grift. They sued. They said, we don't want any of that to end. So they applied for a TRO. And then the lower level judge, Breyer's bro, came out and said, the district court said that there was no evidence at the hearing that the National Guard were engaged in any other activities than what was articulated. So the judge is saying, okay, we're going to cabinet to this kind of appeal. So what happened is, after the judge gave it back to Gavin, Trump immediately appealed, filed an emergency motion to stay this pending appeal. And the court, Ninth Circuit, issued the stay. Remember, that was the time Gavin came out. He's like, I'll have it tomorrow. He's like, oh, no, you didn't even last 12 hours, idiot. So we now grant the stay, right? Trump asked for an extension of that administrative stay. They say, hold on. So it's like, administratively, if you order us to give back the National Guard like tomorrow, it's going to cause a bunch of problems. Like, they're all going to have to pack up and start leaving and then whatever. So we're not going to do that. So 3 days, just quick stay. Let us consider it a little bit more. Emergency oral arguments. We have them. We get the presentation. They come out now with the final order pending the rest of the appeal, which will take a lot longer to brief in full and maybe have more oral arguments on the merits of the case, because Gavin brought 3 claims and we were just kind of talking about the preliminary injunction at the moment. Now, meaning Breyer loses, and he's going to lose this entire time. So he's going to scramble around to keep this case, and he's going to probably do that just like Boasberg did, just like Zenas did. They get scolded by the Supreme Court of the United States. Hey, Boasberg, you have no jurisdiction over this case at all. Why are you keeping it? Because they're laughing at John Roberts. John, they are. They don't care. They're snubbing you, man. All right, we now grant the stay. Trump wins. Gavin loses. Again, says Trump has made the required strong showing that they're going to win this thing. Now, we disagree with their primary argument from Trump that Trump's decision to federalize members is completely insulated from judicial review. Nonetheless, the Court of Appeal says you still win. Under longstanding precedent interpreting this statute, our review of the decision must be highly deferential. We don't have to avoid looking at it, but we do got to give you kind of the benefit of the doubt on a lot of this. Now, affording the president that defense, we conclude that it is likely that Trump lawfully exercised his statutory authority, which authorizes federalization of the National Guard when the president is unable with regular forces to execute the laws of the United States. So good. It's right. It's true. And all of these protests, like, they're not saying this, but this is the truth of it. Trump is not able to execute the laws when you have flash mobs of citizens or not. I don't care if they're illegal or citizens, whatever it is. They're standing in the way, obstructing federal agents. We had like 1,500, 1,600 J6ers rounded up for obstructing something when they were invited into the building. Not all of them, but many were. Now, additionally, the Secretary of Defense transmittal of the order, as you see here, is also authorized under the law, and it satisfied the procedural requirement. Okay, it went through Gavin's office. That's enough. And even if there was a procedural violation, the Ninth Circuit says that would not justify the scope of the relief here provided by Maniac Breyer. Our conclusion that it is likely that the president's orders federalizing the California National Guard also solves the 10th Amendment claims, because they say the 10th Amendment claims is based on the statutory claim. And so we find in Trump's favor and we grant the motion for a stay pending appeal. Oh no, California, you're gonna have a little semblance of law and order, and the National Guard can come in here and repel the illegal invaders out of our country. Oh no, so hard for you, I know. On June 6th, here's the background. A group of protesters tried to prevent ICE from operating in LA by throwing objects at ICE vehicles. Yeah, we were here, we saw it. Later that evening, protesters gathered at ICE and buildings downtown, and they pinned down federal officers. This is the real J6, to be clear. The real J6 is happening right now in California. A sustained, weaponized operation against federal officials. Not a 4-hour protest over a stolen election, which was clearly stolen, as we're learning, in multiple ways. The protesters used concrete chunks, bottles of liquid, including flaming liquids, and other objects at the officers. They used large rolling commercial dumpsters. This is the Ninth Circuit writing. LA Police Department arrived on scene about an hour after being called by officers. The protesters eventually dispersed at law enforcement direction, but the federal building had been heavily vandalized. The next day, on J7, as the 2-day assault occurred, protesters continued to interfere with federal enforcement operations, continuing to damage federal properties. Didn't happen on J6, allegedly. In a confrontation that lasted over 7 hours, J6 was about 4. This was on day 2. J6 was about 1. They were back in the building that same night. No problems the following day. And a lot of this was instigated by guys like Ray Epps on J6, January. The protesters blocked traffic. They used shopping carts. They barricaded the street. CBP officers were boxed in. They were throwing mortar-style fireworks at everybody. Other protesters engaged in dangerous behavior, like throwing rocks from bridges, including a Molotov cocktail at deputies. They were burning a vehicle. They were vandalizing property. One ERO officer was trapped in her law enforcement vehicle while protesters surrounded it, and she didn't shoot anybody in the neck. Violently pounded and shook it and threw stones at it. One officer suffered a shattered wrist caused by a thrown object. They also damaged the perimeter fence of the federal building. Now, in response, Trump came out and he said, all right, enough of this crap. On J7, he called into federal service 2,000 National Guard. He said, all right, these invaders must go. Later that evening, Hegseth came out, issued something. Now, protests against federal officers continued into the following days. For example, during the night of June 8th, protesters in downtown LA set off commercial-grade fireworks towards federal officers. They threw objects at passing law enforcement vehicles. They lit fires in dumpsters, vandalized dozens of buildings with graffiti, including the federal courthouse. On June 9th, the assault continues. A crowd of 1,000 protesters gathered near a federal building. And that means that federal building cannot operate, okay? The whole building is shut down. What are you gonna do? Come in and out of the gates when there's 1,000 people there? You can't come in and out of the gates. You can't conduct your ICE operations there. That's the point. It's 1,000 protesters. On day 3 of this, J6 started 3 days ago. One protester drove by the building, fired paintballs, projectiles at officers, hitting at least one in the head and the neck. At another federal building, protesters attacked a federal van carrying multiple non-citizens and officers, rocking the vehicle and smashing its windows. Let our illegals go, they said. Let them out. Release them into the country. What if somebody did that when the FBI lunatics came in and kicked in one of the J6ers' doors and Americans stood up and stopped that from happening? What would they have done? They would have shot everybody in the crowd and called it a domestic terrorist attack, and then said, well, we couldn't figure out what to do about it because of sloped roofs or something like that, right? Because they're so incompetent when they need to be. The building had to be closed for most of the day, remained closed the next day too. Congress was back open on January 6th. Remember, they came that same night, disrupting the operations of many federal agencies working in the building. On June 9th, in response to these events, the secretary issued a second memo calling another 2,000 in. That day, plaintiffs sued. So Gavin comes, how dare you kick illegals out? Said, this is ridiculous. This is outside of the law, ultra-virus. This is against the 10th Amendment, which reserves rights to the states. And it's an administrative claim that allows us to use this catch-all provision in and sue for anything else that the law doesn't provide for elsewhere. It's like a kind of an umbrella protection provision. Now, the complaint seeks relief. Court of Appeals writes, so then on June 10th, Gavin came out and he said, we're going to suffer immediate harm. Judge Breyer, help us. There's a high risk of substantial unrest and that the National Guard are spreading fear. And they're the ones who are actually destabilizing the country and the community, and that we don't need them. And that if you use us as National Guard for this, then we can't stop drug trafficking. It's like, hello, what do you think a lot of this is based around? Trafficking across our border, including drugs and kids, which you forget about. Help fight forest fires, Gavin, which they've done such a good job on, having some of the most beautiful cities burnt to the ground thanks to the mayor and Gavin. Defendants opposed the motion. Trump said, ridiculous, okay? We're going to federalize this National Guard. In fact, you can't even stop us. So leave us alone. It's non-justiciable. The judge can't even review it. Well, the judge said, oh, yes, I can. I'm the president now. He said that, well, before we get into it, we do agree that the president could operate, right? Everybody agrees like the president could do it, but Trump just didn't do it right. Parties agreed. Does he have authority under either one of these? I'm sorry, they're not defaulting to that. They're just saying, is it yes or no for that provision or for this provision? Yes for that, yes for this. The district court then determined from Breyer that Gavin was going to win. They said, first of all, this is outside the law. The conditions that Trump invoked to federalize this was not satisfied, right? In other words, this is not a rebellion. We saw that language. The judge said, like, rebellion has to be, or if Claudia Sheinbaum, she did say that, so that wouldn't work. Or if the president of the Senate would say, oh, he did say that, so that's not going to work. So it'd be like if somebody, like in Venezuela, like Maduro, oh, wait, he didn't, oh, he said something like that too. So I don't have any good examples for you, but the judge made a definition of rebellion that you couldn't meet, even though we looked it up like 5 times in 5 different dictionaries. Oxford, Merriam-Webster's, Black's Law, all of them said rebellion. It's obstructing or rejecting the lawful authority of the sovereign government. That's all. It's not complicated. That's clearly what's happening. And the judge is articulating that for us. But Breyer was like, no, they're just peaceful people and they just want to improve their lives in pupusas. And because the federalization order was not issued through the governor, right? He said, well, you didn't send it like via email and I didn't get CC'd on this. Too bad. Now, based on the conclusion that Trump acted without authority, the lower level maniac judge also concluded that Gavin was going to win on the 10th Amendment claim too. Then he didn't want to act on Posse Comitatus, right? He says, I'm going to decline to talk about that, which is using the military to do basically law enforcement on the streets. Can't do that unless there's certain exceptions. But they say there's no evidence here that they were engaged in any other activities. So we don't even need to get into that because they were only doing federal building stuff. Now, they did not yet contend that the National Guard members have participated in any arrest in violation of Posse Comitatus. And so that really hasn't come up. But then Breyer says that the lower level judge, that Gavin did suffer irreparable injury by having the National Guard come in here and stop illegal invaders from wrecking federal buildings. They suffered, and said that while Trump has no doubt in protecting federal agents, he didn't have the authority here. He said the National Guard is just making things worse and they're going to deprive the state of its own people in the National Guard. Amazing. And then stayed its order until June 13th. Gavin came out and said, I'll be in charge tomorrow, then was reversed immediately. Now, Trump immediately filed a notice of appeal and was successful. We held oral arguments. We talked about it earlier this week. Now, ordinarily, we lack jurisdiction, but we're going to hold on to it using these other provisions of the law. And this is essentially a preliminary injunction because of the effect of the order from the lower level judge. Not a TRO, it's a preliminary injunction. Since it's in effect a PI, the court can hear it. We got it. Then they give us their standard of review. How are they going to analyze the lower level ruling? And they're using the traditional state factors, which we talk a lot about here. So in summation, here is how they apply the rules. Now, in determining whether Trump made a strong showing, we address only the issues that the lower level court resolved. Now, Trump argues that Breyer erred in concluding that the Gavin claim can even be filed. They also say that he made a mistake in concluding that they were going to win, saying that the federalization is not allowed. And so we're going to be talking about certain things, but not other things. But here they say, Trump says, you can't even listen to this at all. It's a political question. Gavin can't handle this, and your court can't handle this either. It's our decision, so you're done. They say, we disagree. We're going to hold on to this case. It's not a political question, and we have power. And we also can review this case. And here's Marbury versus Madison again. And Judge Alito just gave an interesting interview, I think with the Hoover Institute, just this week. And he was talking to the host about this. And the host referenced an old quote from Scalia, which was challenging Marbury versus Madison in a way, right? Asking about where did that come from? We should reanalyze where that came from. Is that in the text of the Constitution? Very interesting. Anyways, so they're relying back on Marbury versus Madison. This is obviously the seminal case that establishes judicial review. And they say, can we review? It's Marbury versus Madison. Madison. The statute says we can. Trump says we cannot. They cite these cases, but in those cases, they're different. The question here then, if we can look at it, the question is, how hard can we look at it? Do we owe the executive branch any deference? And if so, how much? Now, again, that's a question of interpretation. You have to look at the statute and say, how much does it? What does it say? How do we analyze this? They say, if we were to analyze the text alone, we might conclude that the president's determination is subject to review like certain other factual findings that are preconditions for executive action under a statute. They say, well, we could say that this is like another law where, it says Trump or the president can do this if this, this, and this. And they say, well, like those statutes, did that happen? And we can go look into those. But this is not a blank slate. They say, sorry, the history of Congress's statutory delegations and other cases strongly suggests that our review of the president's determinations is especially deferential, meaning we can't override you. Congress first delegated a lot of this to the president back in 1792, recognizing that Congress is not a good body and too slow to deliberate when you need to send in the National Guard because your country's been invaded. All of it has been in place for a while. 1795 Act contained a predicate called invasion. It said whenever the United States shall be invaded or in imminent danger of invasion, it's lawful for the president to call forth members of the militia as necessary as he may judge necessary to repel the invasion. The Supreme Court interpreted that, which arose out of Madison's decision back during the War of 1812. Jacob Mott, a New York militiaman, refused to turn up to service. He was court-martialed and fined back in 1812, and the state seized his property to satisfy the debt. Then he sought an action for a plebeian in state court, arguing the seizure was illegal because Madison's order that federalized the militia was invalid. The Supreme Court said, you lose. The court began by explaining the Constitution gave the calling forth power to Congress. Of course, we saw that. But Congress confided that and delegated that back over during the exigency of an invasion, right? You can't have Congress like, get everybody together and vote on this. We're being invaded. Should we schedule the vote next week? Yeah, by then they'll be in Washington, and that'll be perfect time. Great idea. So they just gave it to the president. Court recognized that the delegated power was limited, confined to actual invasion or imminent danger of invasion. And the court answered that question by saying, well, the president, he decides. Like, what does that mean? The president does. Because Congress can't decide. Courts can't decide. The president is the only person in place to handle that decision most efficiently. Now, they also note, Gavin said, that there are some differences between that case and this case, and so they spent some time distinguishing the two. But in summation, they'll say that California says that case is old. Like, so what? It's old. It's like, so what if the president has a lot of discretion? It's old. Things are different now. We're progressive now. We have 15 genders. You can't even believe it. Things have changed. And it is in some tension with more recent decisions like the AEA and some other cases. But all that said, the case does not compel us to accept Trump's position that he could federalize the National Guard based on no evidence whatsoever, right? So it's not so broad that Trump can just say, you know what? Federalize for whatever reason. And that the courts would be unable to review a decision that was obviously absurd or made in bad faith, right? Trump comes into California, or he goes into Michigan, or he goes into New York with Hochul, and he says, all right, no more Botox on faces. Anybody who has their face drooped off because they have too many Botox shots in there and then are called in front of a press conference, National Guard is going to stop the Botox injections because nobody can see if our governors had strokes or not. We don't know if they had a stroke or if it's just their face falling off. So the National Guard is going to come in here and stop that. They would say, you can't do that. That's not really an imminent threat to the country, even though we might disagree, and say that's been absurd or bad faith. And I don't know if that's the standard or not. We'll see. But in Martin, the court addressed that argument. They said, well, it's the president. It's limited. It falls within the discretion. And so there is a lot of deference. And so with all of that in mind, we consider whether the president exceeded his authority. The lower level judge says he did. But as Trump says, that law, that section cannot be read to mean that as so long as some of the execution of powers are possible, the statute cannot be invoked. The logic of it doesn't make any sense. Now, under a highly deferential standard of review, Trump has presented facts to allow us to conclude that Trump had a colorable basis for invoking the law. Trump and the defense presented evidence detailed above of protesters' interference with the ability of federal officers to execute the laws. Obviously, we watched it on TV. Leading up to the president's federalization of the Guard on J7. There is an evidence that the day before, protesters threw objects at ICE and that the ICE agents were trying to complete law enforcement operations. They pinned them down. Several officers who were defending federal property. Many got hit with concrete chunks, bottle of liquids, and other objects. Large rolling commercial dumpsters were used as barricading rams to breach parking lot buildings. They vandalized buildings, threw objects, including Molotov cocktails, according to multiple people, all submitting declarations. And so if all of that, if we just afford some deference to the president on that, he acted within his authority. So So then Gavin complains, well, you didn't go through our office. Remember, the judge was like, also, you have to go get permission from Gavin and CC him on this, even if he's in a Botox meeting. Defendants argue that they complied with the procedural requirements because the president called Newsom, said, get your act together. Hegseth sent a memo to the adjutant general in California and even put on it through the governor of California. We even titled it. Trump also says that even if they erred as a technical matter, any procedural error cannot justify the injunction because Trump is not legally required to get consent from Gavin. And so they say, Court of Appeals, Trump likely met this procedural requirement as well, because under California law, the adjutant general is the chief of staff to the governor, and the duties include issuing all orders in the name of the governor. So Gavin doesn't even write his own orders. He's got some dude to do it for him, or it's California, so I don't want to presume that. Plaintiffs do not dispute he got the memo, relinquished command accordingly, and even forwarded it to Newsom. Everybody did everything above board. Although Gavin did not personally issue the order, the law says it goes through the governor. It doesn't go directly by the governor, Gavin. Nothing in the law prevents the state from delegating to a subordinate, like the general, the authority to release the control. Even if the statute contemplated strict adherence to this process, the rest of the statute provides that Trump is right. It says this law doesn't give governors any veto power over any of these decisions. And it says things like you got to be consulted about an order. It doesn't say anything like the governor be consulted about it. It's not supportive of the language in the text. You think it says that, but the law says it does not say that. So in any event, even if Trump failed to comply with these procedural requirements, such failure would not justify the relief that the judge gave below. It's like just a clerical error. So what? Because it didn't get CC'd to Gavin specifically? No. In sum, Trump complied with the law, the procedural requirements, and all of the other requirements. And so from the Court of Appeals, Trump wins. Gavin says, but the public, we're going to die. The National Guard members are going to make things worse. They could be fighting forest fires, which apparently they don't, and combating drug trafficking, which is part of why ICE is there arresting people who are illegal invaders who traffic themselves, along with drugs and children, into our country, and more. And so in conclusion, Gavin loses again. For the reasons above, we grant Trump's motion for a stay pending appeal, right? So for this, this is a solidly well-reasoned, obviously accurate decision. So the idea that this, and this was 3-0, looks like per curiam. One of those isn't a blue judge, but doesn't look like Gavin is going to have a fair prospect of reversing this, at least anytime soon. So he loses again, and I'm sure he will come out with a new social media post about why this is actually a victory. We'll wait for that one. But we did go back down into the district level court, and we had a hearing today, right? So after that dropped late last night, we came back down to the district court, and Margot Cleveland was listening to the arguments that took place today because this Judge Breyer just got backhanded by the Court of Appeals, right? They just said, you're an idiot. You've done a terrible job. All of your relief that you granted was way overbroad. It is a rebellion. Trump was following the law through the governor is not accurate, and you're just terrible. You're not good at this. So he says, well, okay, we're going to have a hearing about this. It came back down to his court. Margot reports. Now, the hearing was supposed to start at 10, but it hasn't for whatever reason. And so she's going to go pick up some plumbing parts. Nice. I hope it was successful. Maybe some Schedule 40 PVC. It says, okay, so this is the docket. Now, hearing is starting from Breyer, the judge. Says, okay, well, I guess we're all here today. Happy Friday. And I would imagine everyone had a late night. That's kind of how he sounds, actually. He says, let me review, because they all got the decision from the Court of Appeals. We just read it right there. He says, let me review where we are, as that informs where we're going to go. He says, the court granted the TRO, I did, right, Judge Breyer, and the Ninth Administration administratively stayed the decision immediately. Remember, we saw that. And then stayed it again pending appeal, which we just read. He says, in their order, the Ninth Circuit, they said that this is effectively a preliminary injunction. And so they've got jurisdiction over the case. And if they have jurisdiction, then the lower level court doesn't. Now, I'm a district court. My decisions are reviewed by the Ninth. And so just as you can't ignore my decisions, Breyer says, I can't ignore the Ninth. And so the issue is precisely, how do I do that? What do I do? Now, as we saw in the Court of Appeals, there wasn't a part about Posse Comitatus, which the Court of Appeals decision did talk about, which was making arrests, using the military as law enforcement on American streets, kind of subverting other law enforcement efforts and supplanting the police. He said, well, because the district court plaintiff argued certain points violate Posse Comitatus, the Ninth Circuit said that the Posse Comitatus issue is not before us, right? So the Court of Appeals, we didn't hear that. So he says, it's not clear to me that the Ninth Circuit stay divests this court per their decision to grant or modify Posse Comitatus. This judge just got obliterated and stayed. So I think the district court might have the authority to modify my injunction to fit it under another provision of the law because he's a scammer. Now, he says, well, I'd like to ask for briefing on this. Can I modify my injunction under Posse Comitatus? Depending on what you say, I'll decide what I want to do. And just like Hackjob, Boasberg, and the rest of them, they find ways to hold on to a case, even when the courts of appeals say no. So Newsom's attorney says, Your Honor, can I say something? And I need to talk right now. I got soccer practice starting in 6 minutes. Says, here's the question. Well, only if it has to do with Posse Comitatus. Well, we believe another issue is live, Your Honor, and you can still act on this case right now. Take it back from the Court of Appeals, which is the length of the federalization. The judge says, well, the TRO ends in 14 days. That's the difference. No, that's only one difference, Your Honor, respectfully. Well, now the judge says that this has been converted to a preliminary injunction, and now I don't have jurisdiction over the preliminary injunction. The Ninth Circuit does. You're asking, what is the duration of the National Guard? And I've understood it's been nationalized for 60 days, and so I'm stayed. Well, Your Honor, 60-day time limit, but with flexibility for that time to change, or at least at the discretion of the defense. And, says the DOJ, Newsom says, well, because it is renewable, we believe another issue is when it should end. We want the court to put an end date on that. So, well, okay, well, put that in your briefing and I'll address it. Sorry to ruin your weekends. So briefing is due on Monday. Margot says, yeah, he's going to find that he still has this case because he's a Boasberg protege. And he's going to just keep the case because they're political hacks, not fair and impartial judges. But the Supreme Court and their case today also obliterated Gavi Poo. You see, this was the case that came down, Diamond Alternative Energy versus the EPA. And it's a 48-pager dropped from Judge Kavanaugh that says Gavin loses again. Now, what happened in the background here is California came out and they issued these regulations. It says if you're a disgusting gas-making car maker, your vehicles have to decrease emissions and you have to limit greenhouse gases so we can make room for more illegal aliens. And they submit standing declarations. They say California's regulations are a big problem for us if you're an automaker, saying nobody wants our cars anymore. The producers actually can't do anything. And this is causing actual damages to the auto companies. Now, the EPA did not challenge their standing before, and California and other states adopted these same regulations, and the EPA was defending them. California said that fuel producers can't sue. You can't sue. Sorry, it's federal decision, state decision. So if you've been injured and we are now in charge of your product to save the planet, which is to wreck American industry, to limit consumption, and to make you feel better about the fact that they're stealing your money and livelihood right away from you in the name of saving the planet, while other countries are taking over nuclear power, solar power, drone technology, maybe AI technology, and more. So we've got a lot of problems here. But they said in the Supreme Court that fuel producers from these car companies do have standing. They are being injured. The fuel producers' injury, in fact, are pretty straightforward. In fact, undisputed. The fuel producers make money by, selling fuel. So decreased purchases of gasoline and other fuels are injuries, monetary injuries. Now, the California EPA and their approval is enforcing regulations saying you have to essentially reduce your consumption. The fuel producers are being injured. The car companies are being injured, and they're direct objects of this regulation. And this is a familiar circumstance where government regulation of one business may be likely to cause injuries to other businesses, including gas-powered vehicles and more. And so EPA in California say you can't sue. Okay, we're dictators here. Only illegal aliens can sue in this country. You have no rights. Just close your business for 14 days and just deal with it. Record evidence says invalidating these regulations would mean that these businesses are not being strangled by green lunatics. And so this case does not involve other rare instances where markets can be permanently changed to invalidate regulations. And so in some, they can sue. The evidence that some automakers are in compliance suggests that not all automakers would respond to invalidation. So this has all been reversed from Judge Kavanaugh, and it's actually a 7-2. Okay, so yep, you can sue. And it's not justifying or deciding this on the merits. It's just saying there's enough harm. They have standing. They can sue. You just can't sue if they steal an election from you. If they pass regulations to steal your monetary income, you might be able to sue. Supreme Court says you can't sue, in fact. But if they sue, you sue because they stole an election from you, you've got no standing at all, and things are moot. So Gavin having a tough time. 2 cases. He just lost there. Breyer, the judge in the Northern District of California, will do everything he can to hang on to this case. We'll keep our eye on it. Thank you for subscribing to our channel and joining as we cover this case and many more, and we'll see you back here on the next one.